Hi, I'm attorney Eric Lewis. For the next few minutes or so, I want to talk to you about handling a debt collection lawsuit. The way debt collection happens does vary from one jurisdiction to the next, so keep in mind that what I say here is generally applicable to Indiana, and more specifically the 9-county Indianapolis region. Now, a quick disclaimer, what I say here should not be construed as legal advice that's applicable to your unique situation. Everyone's situation is unique, and I provide this merely as some helpful guidance. If you're in doubt, you should always consult the legal advice of an attorney. Now, a debt collection lawsuit begins with the defendant being served with what is called a summons and complaint. Generally, we call them lawsuits, but the legal term is complaint, and you'll see on it that it says that you've been sued by the above-named plaintiff. Service on the defendant can be made in a number of ways, but in Indiana it's generally done by either a sheriff's deputy in person or by certified mail. A lot of people will look at the complaint and say, hey, there's no court date on here, so I don't have to do anything, I'll just wait. And that's completely wrong. Very few courts will automatically issue a court date with the complaint. In Marion County, the 9 different township small claims courts will usually put a hearing date on what they call the notice of claim, but pretty much everywhere else, Hamilton, Boone, Hendricks, the Marion Circuit and Superior Courts, they'll simply say that you have X amount of time to respond. And when service of the complaint summons is made by sheriff, you have 20 days to respond with what is called an answer. The answer is basically your legal response to the allegations set forth in the complaint against you. More than anything, this is where people who don't seek legal advice will mess up the most. If you don't get your answer in with the court within 20 days if you're served by the sheriff, or 23 days if you're served by certified mail, the plaintiff can ask the court for a default judgment against you. So review the complaint very carefully, and if there's anything about it that you outright dispute or cannot verify on your own, that's when you would file an answer saying so to preserve your right to defend against the lawsuit. Now, keep in mind, this is a very minimum and basic approach to handling receipt of a complaint and summons. Hiring a lawyer will of course help you make sure that your answer is adequate and properly made to protect and preserve your rights. If a default judgment is entered against you, it'll be for the amount asked for in the complaint plus all fees and court costs, all together with interest that accrues at 8% until the judgment is fully satisfied. Also keep in mind that once the debt collector has a judgment in their favor, they're going to go about finding a way to get paid. And this will often include wage garnishment, freezing bank accounts, or seizing and liquidating non-exempt property and assets. So this isn't something to take lightly or just sit by and like put your head in the sand like that you don't want to try to avoid it. So your best bet is to seek legal counsel at your earliest convenience so you can tackle this before it gets out of hand.